No humans were harmed or even used in the creation of this program. We created it from a script written by the presenter using a generative artificial intelligence platform. We hope you enjoy it. Welcome to today's program, What Does ABA Model Rule 2.1 Require of Lawyers? My name is Zach McGee. I'm a Senior Vice President, Business Affairs for Sony Pictures Entertainment. Prior to joining Sony Pictures, I was an in-house lawyer at NBC Universal, and before that, I was a lawyer at Davis Polk. I've been writing and speaking on legal education topics for the past 20 years, including having taught a course on legal ethics at Pepperdine Law School. As you might expect, I am speaking today solely on behalf of myself, and my views don't reflect those of my current or any former employers or institutions with which I've been affiliated. I want to start by asking all of the smart and experienced lawyers who are watching this program a question that is a bit of a brain teaser. Is there a legal ethics rule that no lawyer ever has been sanctioned for having violated? And if so, which rule is that? What do you think? Do you need a couple more minutes to chew on that one, or does the title of this program give it away? Actually, the answer to my question is no, there is no such rule, or at least none that I am aware of. But the rule that comes closest to never having been used to sanction lawyers is ABA Model Rule 2.1, which is our subject today. Now, I am not trying to be tricky because, of course, no lawyer technically is ever sanctioned under any of the ABA model rules. We all know that lawyers are governed by their state's legal ethics rules and not the ABA model rules. But when I say that almost no lawyers have been sanctioned for violating ABA Model Rule 2.1, I am talking about ABA Model Rule 2.1 as it has been adopted by the various states. For simplicity, I'll just refer to ABA Model Rule 2.1 in our discussion today because that rule has been adopted by nearly every state with few, if any, changes from the ABA's version, including in both California and New York, where I am a member of the bar. Incredibly, this program is the 11th program in our legal ethics series of CLE programs. If you enjoy it and would like to view more programs in this area, we have quite a few more to offer you, and those additional programs most likely are available on the same service where you are watching this one. In our first program, Representing the Devil, we examined an important question. What are your legal and ethical obligations when your client turns out to be the devil incarnate, or at the very least, a very bad and unethical person? Using the criminal fraud and conspiracy convictions of pharma bro Martin Shkreli and his lawyer Evan Griebel as the backdrop for the discussion, I offered practical guidance to lawyers should they ever find themselves representing a smart, arrogant, and manipulative fraudster. Our second program, Trump, Gawker, and the Legal Ethics of Alternative Litigation Finance, discusses the legal ethics issues that arise when someone other than the plaintiff is funding a lawsuit, which often goes by the name Alternative Litigation Finance, or ALF. We examine these issues in the context of the two most famous ALF lawsuits that have been prosecuted to date. E. Jean Carroll's lawsuit against former President Donald Trump alleging that he sexually assaulted and defamed her, and Hulk Hogan's lawsuit against the gossip website Gawker, alleging that the site invaded his privacy when it published a sex tape in which Hogan appeared. Our third, fourth, and fifth programs are parts 1, 2, and 3 of The Dirty Dozen, where we count down the 12 most unethical lawyers in the history of lawyering in the United States. The stories of the illegal and unethical conduct of these lawyers are cautionary tales for any lawyer who values his or her law license. For our sixth and seventh programs, we talked about ChatGPT and other generative artificial intelligence platforms and the legal ethics risks these technologies create for lawyers who may be tempted to use them in their law practice. This includes the ChatGPT lawyers' sanctions case, where a New York federal district judge sanctioned 2 lawyers and their law firm under Rule 11 for submitting a brief that cited to 6 federal court decisions that did not in fact exist. In a case of seemingly first impression, ChatGPT had made up these cases out of whole cloth, and the lawyers failed to do any independent verification of those cases before filing their brief. The other program, Understanding and Managing Generative Artificial Intelligence, AI, Legal Practice Risks, provides an overview of this technology to make sure you understand exactly how these tools work, what they can do and what they can't, how reliable they are or aren't, and most importantly, what legal ethics issues can arise. Our 8th program, California Joins the Rat Pack. Navigating New Rule 8.3 discusses the new Rule 8.3 that requires California lawyers for the first time to report misconduct by other lawyers. This program includes a thorough discussion of ABA Model Rule 8.3, upon which California's Rule 8.3 is based, as well as a review of the difficult issues that both California's Rule 8.3 and ABA Model Rule 8.3 raise for practicing lawyers relating to self-reporting, confidentiality, and discipline. Our 9th program, Drawing the Line Between Witness Preparation and Unethical Witness Coaching, answers the question, when does ethical witness preparation cross over into unethical witness coaching? The ABA Ethics Committee recently issued Formal Opinion Number 508 that attempts to draw this line with special attention to the unique issues that can arise in remote proceedings. That program also reviews the many benefits of using a deposition prep video with witnesses to help prepare them to testify. Finally, our 10th program, Ethically Bankrupt, the Judge David R. Jones Sex Scandal, discusses the judicial and legal ethics issues that arose out of the bombshell sex scandal that one commentator called a body blow to the integrity of the entire bankruptcy system. The facts of this case are so sensational. A bankruptcy judge who was living and sleeping with a lawyer who regularly appeared before him, while at the same time approving fee applications for the lawyer's legal work in those cases, they would be hard to believe if they weren't true. So, if you are a legal ethics junkie, or more likely, someone who simply needs to fulfill his or her legal ethics CLE requirements, then you've come to the right place, and I hope you take advantage of some of the other programs that we have available in our legal ethics series. Returning to today's topic, perhaps because ABA Model Rule 2.1 doesn't see much action in attorney disciplinary proceedings, it is frequently overlooked both by commentators and practicing lawyers. I think that's a mistake because it is a very important rule, and to my mind, a very useful rule that I believe lawyers should keep firmly in mind when we are representing our clients. Plus, just because very few lawyers have been disciplined for violating ABA Model Rule 2.1 to date, doesn't mean that you can't be sanctioned if you violate it in the course of your law practice. Let's start with the rule itself, which somewhat oddly is entitled Advisor, and then without explanation is also entitled Counselor. I think maybe the ABA's rule proofreader overlooked Rule 2.1 just like everyone else, but because Advisor and Counselor are for all intents and purposes synonymous, we can skip past that oddity. ABA Model Rule 2.1 provides as follows. In representing a client, a lawyer shall exercise independent professional judgment and render candid advice. In rendering advice, a lawyer may refer not only to law but to other considerations such as moral, economic, social, and political factors that may be relevant to the client's situation. We are going to break down ABA Model Rule 2.1 into the 3 separate and independent duties that it imposes on lawyers, each of which we will then discuss in turn and in some detail. Those 3 duties are 1. A lawyer shall exercise independent professional judgment, 2. A lawyer shall render candid advice, and 3. In rendering advice, a lawyer may refer not only to law, but to other considerations such as moral, economic, social, and political factors that may be relevant to the client's situation. Because the 3rd duty is styled as a may and not a shall, technically it is not an ethical obligation, but rather it is a suggestion from the ABA on how lawyers should behave, so that is an important distinction for you to recognize at the outset. Unlike nearly all of the other ABA model rules, there is precious little case law interpreting ABA Model Rule 2.1, so we will rely heavily on the comment that accompanies that rule in describing what it requires of lawyers. Let's begin with our first of the 3 duties, which is the duty to exercise independent professional judgment. This duty is the opposite of the other 2 in the sense that there actually is some case law interpreting this aspect of ABA Model Rule 2.1, but nothing at all about it in the comment. The other unique thing about the duty to exercise independent professional judgment is that this is the only part of ABA Model Rule 2.1 that has been used to sanction lawyers. Neither the duty to render candid advice nor the suggestion that lawyers refer to other considerations besides law that may be relevant when rendering advice has ever been the focus of a lawyer disciplinary case as far as I can tell. At the most basic level, the duty to exercise independent professional judgment means that a lawyer's judgment should not be influenced by considerations other than the desire to protect and to serve the client and his or her interests. There are two primary danger areas here: the lawyer being influenced by his or her own interests, and the lawyer being influenced by the interests of a third party who is not the client. And those possibilities are aptly illustrated by the handful of cases in which lawyers have run into problems for having violated ABA Model Rule 2.1. These cases are still exceedingly rare, and beyond that, the two contexts in which these cases have arisen could hardly be more different. The first context is cases where a lawyer is in a sexual relationship with the client, and the second context is where someone other than the client is paying the lawyer's bills, such as the alternative litigation finance scenario, or where an insurance company is paying the lawyer's fees on behalf of the client. We'll look at each of these in turn to further flesh out ABA Model Rule 2.1's requirement that lawyers exercise independent professional judgment. The topic of lawyers having sex with clients is a massive one that would require its own CLE program to do it justice. As you probably know, the ABA model rules prohibit lawyers from having sex with current clients unless the relationship existed before the representation began. Specifically, ABA Model Rule 1.8J provides that a lawyer shall not have sexual relations with a client unless a consensual sexual relationship existed between them when the client-lawyer relationship commenced. Most states have followed the ABA's lead in prohibiting sex with current clients, although this is one area where there is some divergence among the states that have adopted the ABA model rules, so lawyers need to check their own state's legal ethics rules to make sure you know what your specific state permits before considering engaging in a sexual relationship with a client. That said, we don't need to parse the specifics of any state's rules to follow the lawyer disciplinary cases that have arisen under ABA Model Rule 2.1 where a lawyer was having sex with a client, because the lawyer's conduct in each of these cases was so outrageous it would not have been permitted in any state or at any time. The other oddity here is that there are 5 such cases, and 4 of them involved Louisiana lawyers. The 5th case comes to us from Maine. I'm not sure what was going on in Louisiana in the late 1990s and early 2000s, but suffice it to say, some lawyers in that state were engaged in some very dodgy conduct for which they were severely punished by the Louisiana State Bar. The 4 Louisiana cases are in Ray Ashe, in Ray Shambach, in Ray DeFrancesca, and in Ray Ryland. The main case is Board of Bar Overseers versus Prohlman from 2018. I have included copies of these cases in the written materials in case you are curious what these lawyers did, and I will tell you that they make for pretty interesting, albeit also pretty depressing reading as far as judicial decisions go. To summarize these cases for our present purposes, we have unscrupulous lawyers preying on vulnerable clients, former sex workers, women in abusive relationships, women with drug problems, women going through a divorce, etc., with the goal of coercing the client to have sex with the lawyer. In one particularly egregious case, the lawyer insisted that his client have sex with him as a penalty for having failed to pay the lawyer the agreed-upon fee for his legal services, which he described to her as just like having to pay a late fee on an overdue credit card. You could not make this stuff up. And it would be funny if it weren't so truly awful and reflective of some of the worst abuses of the privileged position that attorneys occupy in our society. The key takeaway from these cases for our present purposes is to understand why the duty to exercise independent professional judgment under ABA Model Rule 2.1 is so important. The Louisiana Supreme Court stated it succinctly in the DeFrancesca case as follows. The particular evil that results from a lawyer's sexual relationship with a client is the loss of emotional detachment, which in turn threatens the objectivity and reasonableness that form the basis of the lawyer's independent professional judgment. The potential for harm which results whenever a lawyer allows his personal interest to conflict with his client's interests is so great that any such violation must be viewed as being very serious, even if actual harm is not readily identifiable. When ABA Model Rule 2.1 requires lawyers to exercise independent professional judgment, what that means is that the lawyer must be objective and not allow his or her emotions, feelings, or interests to affect his or her advice. As the DeFrancesca court observed, it is impossible for a lawyer to be objective when he is sleeping with his client. While I have found no cases on this point, thankfully, another area where I think it might be difficult, if not impossible, for a lawyer to remain objective is where the lawyer is representing a child. All parents know that we cannot be objective when it comes to our children. We love them unconditionally, and in our eyes, they can do no wrong, even when they in fact have done wrong. So that would be another situation where a lawyer very likely could not be objective in rendering advice as required by ABA Model Rule 2.1. Of course, ABA Model Rule 2.1 was not the only legal ethics rule that these lawyers violated when they coerced their clients into having sex with them. Apart from ABA Model Rule 1.8J that prohibits lawyers from having sex with current clients, unless the relationship existed before the representation began, there is also ABA Model Rule 1.7 that prohibits lawyers from representing a client as to which the lawyer has a current conflict of interest, and ABA Model Rule 8.4 that prohibits various forms of lawyer misconduct, including, after its most recent amendment, discriminating against or harassing another person on the basis of sex. At this point, we can leave the cases of lawyers having sex with clients, but I trust you will agree that those cases aptly illustrate the rationale behind a lawyer's duty to exercise independent professional judgment under ABA Model Rule 2.1, which is that a lawyer is expected to be objective in providing his or her advice to a client. These are also the only cases where lawyers have been disciplined for violating ABA Model Rule 2.1. A second context where a lawyer might be at risk of not being objective in providing advice to a client in violation of ABA Model Rule 2.1 is where someone other than the client is paying the lawyer's bills, such as the alternative litigation finance scenario, or where an insurance company is paying the lawyer's fees on behalf of the client. Everyone knows what insurance is, but many lawyers may not know what alternative litigation finance, or ALF, refers to, particularly if you are a transactional lawyer and not a litigator. ALF is defined as the funding of litigation activities by entities other than the parties themselves, their counsel, or other entities with a pre-existing contractual relationship with one of the parties, such as an indemnitor or a liability insurer. These transactions are generally between a party to a litigation and a funding entity and involve an assignment of an interest in the proceeds from the action. ALF has become increasingly common in recent years, leading to significant attention in the legal and popular press, scrutiny by state bar ethics committees, and scholarly commentary. At least some forms of ALF are permitted in many U.S. jurisdictions, including California and New York. If you are interested in learning more about ALF, the legal ethics program I mentioned earlier, Trump, Gawker, and the Legal Ethics of Alternative Litigation Finance explores the legal ethics issues that can arise in ALF cases in detail. As was true in that program, the best way to examine the potential loss of objectivity of a lawyer who is involved in an ALF matter is by referring to the two most famous ALF lawsuits that have been prosecuted to date. E. Jean Carroll's lawsuit against former President Donald Trump alleging that he sexually assaulted and defamed her, and Hulk Hogan's lawsuit against the gossip website Gawker alleging that the site invaded his privacy when it published a sex tape in which he appeared. In case you are not familiar with either of these cases or don't recall the facts of the Gawker case, which happened a few years ago, I'll remind you briefly of them now. In early 2023, Mr. Trump was found liable for sexual assault and defamation and ordered to pay a total of $5 million in damages to Ms. Carroll. That award subsequently was increased by a jury finding of an additional $83.3 million in damages, for an $88.5 million total judgment against Mr. Trump. That lawsuit was funded by Silicon Valley billionaire Reid Hoffman, who was a co-founder of LinkedIn and also a founding board member of PayPal. Mr. Hoffman has been very vocal about his hatred of Mr. Trump, and that seems to be his primary motive in funding the Carroll lawsuit. Turning to Hulk Hogan and Gawker, back in 2016, Gawker was found liable and ordered to pay a staggering $140 million to Mr. Hogan. That lawsuit was funded by a different Silicon Valley billionaire, Peter Thiel, who coincidentally also made his initial fortune as a founder of PayPal. In fact, both Thiel and Hoffman are part of the so-called PayPal Mafia, a network of well-connected tech executives and investors who got their start at the payments company in the late 1990s. Mr. Teal hated Gawker because that website had outed him and some of his friends for being gay some years earlier, and Mr. Teal was funding Mr. Hogan's lawsuit with the stated goal of putting Gawker out of business. So, incredibly, the two highest profile ALF cases to date were both funded by Silicon Valley billionaires, who chose to do so not as investments, as most people who provide ALF funding these days do, but for purely personal reasons, and also that in each case, the plaintiff ended up prevailing and winning huge judgments. The Trump verdict and jury award are still pending on appeal, but the Gawker case ultimately was settled, with Gawker agreeing to pay $30 million to Mr. Hogan. In 2020, the California State Bar Committee on Professional Responsibility and Conduct issued Formal Ethics Opinion Number 2020-204, in which the committee expressed great concern about a lawyer's duty under ABA Model Rule 2.1 to provide candid advice and to exercise independent professional judgment in ALF cases. The opinion observes that litigation funding, like a third-party payer, introduces a third party with its own interests into the lawyer-client relationship, posing risks to the lawyer's independent professional judgment and the relationship of confidence between the lawyer and client. The duty of loyalty and independent professional judgment require the lawyer to act in the client's interest at all times, and particularly where the client's interest might depart from the funder's. The lawyer's independent professional judgment may also be impaired if the funding arrangement imposes limitations on how the case is litigated. The opinion concludes, the committee does not reach a general conclusion that any particular degree of control is per se unethical. However, it is clear that where the funder has some degree of control of the litigation, the lawyer has an obligation to advise the client about the impact of such limitations on the lawyer's representation. A lawyer's duties are not dictated by the funding contract, but by the lawyer's ethical duties. Of course, we don't know whether any of these potential issues came up in the Jean Carroll or Hulk Hogan cases, but you can imagine a couple of possible scenarios. Let's say that prior to trial, Mr. Trump had offered to settle the case for $1 million, and Ms. Carroll was interested in discussing a settlement in that range. But Mr. Hoffman opposed and had an approval right over any settlement, hoping instead for a large jury verdict that could inflict real damage on a billionaire like Mr. Trump, which, of course, is what ultimately happened. Similarly, let's say in the Hulk Hogan case that Gawker had offered to settle by pulling down the sex tape and the associated commentary, but was unwilling to pay any monetary damages. If Mr. Hogan's primary interest had been in getting the tape and article taken down, and Mr. Teal's primary interest was in winning a large monetary award against Gawker to recoup his costs and to put Gawker out of business, and Mr. Teal likewise had an approval right over any settlement that could have created a potential conflict between Hogan and Teal. Or you could imagine the opposite case where Mr. Teal grew tired of financing the litigation and wanted to accept a settlement proposal, but Mr. Hogan wanted to see the matter through to its conclusion, win or lose. In any of these possible scenarios, Ms. Carroll's and Mr. Hogan's lawyers would have had to manage the conflicting interests of their respective clients and their respective financiers very carefully, not only in light of whatever approval rights and other provisions their respective clients had accepted in the ALF agreements they had signed with Hoffman and Teal respectively, as well as their ethical obligations to their clients under ABA Model Rule 2.1. As we have seen, ABA Model Rule 2.1 requires these lawyers to remain objective and not to allow their interests or the interests of any third party in order to fulfill their duty to exercise independent professional judgment. As I am sure you also know, a lawyer's duties under ABA Model Rule 2.1 are exactly the same in cases where the lawyer's fees are being paid by the financier and not the client. Up to this point, we have been talking about AFL matters, which are becoming increasingly common, but are still a lot rarer than cases that involve insurance, which of course are common. In many of those cases, you have an insurance company that is paying the lawyer's fees and is the real party in interest when the time comes to settle the case. For those reasons, lawyers who represent insured defendants have to be mindful of the risk that the interests of the insurance company can threaten to impair the lawyer's ability to give independent advice under ABA Model Rule 2.1. The main difference between an insurance company and an ALF financier is that in the former case, the insurance policy always predates the litigation, and in the latter case, the ALF arrangement gets negotiated once the litigation has been filed or is at least contemplated. That creates special risks for the lawyer who is frequently involved in helping the client negotiate the terms of the ALF deal. Another difference is that, unlike insurance companies who are motivated solely by minimizing cost and avoiding setting bad precedents, financiers can be motivated by anything: profit, spite, grabbing headlines, etc., as we saw with Hoffman and Thiel. As a result, they are much more of a wild card when it comes to managing them, particularly when their interests diverge from those of your client. In closing, in order to fulfill your duty under ABA Model Rule 2.1 to exercise independent professional judgment, you must never allow your personal interests or the interests of any other person affect the advice that you give your client. Let's turn now to the second duty that ABA Model Rule 2.1 imposes on lawyers, which is the requirement that a lawyer render candid advice. In terms of fleshing out this obligation, our first stop is the commentary to ABA Model Rule 2.1. Comment number 1 provides that a client is entitled to straightforward advice expressing the lawyer's honest assessment. Legal advice often involves unpleasant facts and alternatives that a client may be disinclined to confront. In presenting advice, a lawyer endeavors to sustain the client's morale and may put advice in as acceptable a form as honesty permits. However, a lawyer should not be deterred from giving candid advice by the prospect that the advice will be unpalatable to the client. The other comment that speaks to the duty to render candid advice is comment number 5, which states that in general, a lawyer is not expected to give advice until asked by the client. However, when a lawyer knows that a client proposes a course of action that is likely to result in substantial adverse legal consequences to the client, the lawyer's duty to the client under Rule 1.4 might require that the lawyer offer advice if the client's course of action is related to the representation. Similarly, when a matter is likely to involve litigation, it may be necessary under Rule 1.4 to inform the client of forms of dispute resolution that might constitute reasonable alternatives to litigation. A lawyer ordinarily has no duty to initiate investigation of a client's affairs or to give advice that the client has indicated is unwanted, but a lawyer may initiate advice to a client when doing so appears to be in the client's interest. I think the first takeaway here is that the duty to render candid advice under ABA Model Rule 2.1 means that lawyers are not allowed to lie to their clients. If you are giving advice to a client, you are obligated to give your honest view with regard to the facts and the law, and the advice you are giving must reflect your honest assessment of the matters at hand. Now, comment number 1 makes it clear that you can sugarcoat your advice a bit in order to make it more palatable and to help you to maintain a good relationship with your client, as long as you don't cross the line into lying about your advice. Of course, ABA Model Rule 2.1 isn't the only rule that bars lawyers from lying to our clients. There is ABA Model Rule 8.4c, which prohibits lawyers from engaging in conduct involving dishonesty, fraud, deceit, or misrepresentation, and obviously that would include dishonesty toward your client. All of this is straightforward and should be pretty clear to most lawyers. Where the rubber meets the road is where lawyers are providing advice to the client that the client wants to hear, but that the lawyer in fact doesn't believe is accurate, and we will turn to the most famous example of that scenario in a moment. The other aspect of the duty to render candid advice that is important is when a lawyer should render that advice. Comment number 5 makes it clear that in general, a lawyer should wait until the client asks for his or her advice before rendering it. You can imagine many reasons why this is sensible, not least of which the desire for the client to be in charge of the representation. Most clients would not want their lawyers going off on their own and doing legal work and giving them advice that the client hasn't asked for many reasons, not the least of which is the desire not to be paying more legal fees than the client is expecting. But ABA Model Rule 2.1 contains an exception to the "you can wait" rule, which is, quote, when a lawyer knows that a client proposes a course of action that is likely to result in substantial adverse legal consequences to the client, the lawyer's duty to the client under Rule 1.4 might require that the lawyer offer advice if the client's course of action is related to the representation, end quote. So if you know that a client plans, for example, to have a meeting with a competitor to discuss pricing for a product, you can and should step in to advise the client that having such conversations are probably prohibited by antitrust law and could very well be criminal. Once again, this is pretty straightforward in most cases, but as we will see very shortly, in one famous case, this guidance can be tested when lawyers give false advice that they didn't believe was accurate, and because others followed that advice, the lawyers very likely enabled conduct that was criminal. Before we get to the example about which I am guessing you are by now very curious, there are two more aspects to the duty to render candid advice that we should highlight here. First, when a matter is likely to involve litigation, comment number 5 advises that it may be necessary under ABA Model Rule 1.4 quote, to inform the client of forms of dispute resolution that might constitute reasonable alternatives to litigation, end quote. Everyone knows and recognizes, even litigators, that litigation is costly and wasteful, and so when there are options to avoid it, whether that is by way of reaching a settlement or moving the dispute into mediation or arbitration, that is very often in the client's interests, and the lawyer should play a role in steering things in that direction. Clients often get very emotional as it relates to disputes that are headed toward litigation, and so reminding lawyers that we can suggest alternatives that may serve to lower the temperature might help the client more than simply putting on your armor when the client wants to go to war. The other aspect of the rule is that while a lawyer ordinarily has no duty to initiate investigation of a client's affairs, or to give advice that the client has indicated is unwanted, a lawyer may quote initiate advice to a client when doing so appears to be in the client's interest, end quote. This is similar to what we saw earlier. Clients don't want their lawyers running off to investigate their affairs, if for no other reason than they don't want to pay the legal bills for that work unless they asked for it to be done. Yet, there is an exception for lawyers who believe that their advice will help the client. As a practical matter, you'll need to manage when you go off on your own without express client authorization, and most lawyers wouldn't run too far without explaining to the client what they are doing and how it will benefit the client. If you do a good job explaining your thinking, most clients will say, "Fine, let's look into that." So that's generally how the best lawyers manage the duty to render candid advice in the overall context of managing their relationship with their clients. Our blockbuster example of lawyers who failed to render candid advice in violation of ABA Model Rule 2.1 are the now infamous torture memos, which were written by John Yoo, then a Deputy Assistant Attorney General, and approved by J. Bybee, then head of the Office of Legal Counsel, or OLC, of the Department of Justice. Mr. Yoo is now a professor of law at Berkeley, and Mr. Bybee is now a judge on the Ninth Circuit Court of Appeals. As one commentator described them, the torture memos were a cherry-picked, one-sided legal approval of the use of enhanced interrogation techniques, a euphemistic phrase to describe torture such as waterboarding, prolonged sleep deprivation, and mental torment in the War on Terror. The memos, written in 2002, condoned the use of the CIA's heinous torture tactics on detainees at Abu Ghraib in Iraq that led to unresponsiveness, near drownings, self-harm, and even death. Initially, the torture memos were confidential, but in 2004, after news of human rights violations at the Abu Ghraib prison broke, one of the torture memos was subsequently leaked. While both memos were swiftly withdrawn by the OLC as legally defective, the fallout was still astronomical. An internal investigation within the DOJ's Office of Professional Responsibility, or OPR, began, but its report, which detailed just how shaky the legal ground these memos were written on, was not released until 2009. I have included a copy of the 2009 OPR report in the materials for this program. The 2009 OPR report concluded after extensive investigation that both Yoo and Bybee had acted in violation of the ABA model rules, in particular Rules 1.1 and 2.1, by failing to act as competent lawyers or provide candid advice respectively. In condemning them, the OPR found that the memos failed to provide an accurate portrayal of the law surrounding the legality of torture. However, David Margolis, then Associate Deputy Attorney General of the Justice Department, stepped in to vindicate and expunge the records of both lawyers attributing the memo's errors to merely poor judgment. The torture memos were a low point for the United States that likely contributed to more terror attacks against our country because they had condoned the use of torture by the CIA and others in the years following the 9/11 attacks, and their disclosure spurred outrage and inspired further acts of terrorism against the United States in reprisal. Returning to ABA Model Rule 2.1, the 2009 OPR report found that you and Bybee violated that rule because they didn't believe in the advice they were giving that enhanced interrogation techniques did not violate the law. The argument goes that the administration of President George W. Bush was so focused on finding and punishing those who were responsible for the 9/11 attacks that they wanted the DOJ to approve any and all means that might be needed in order to accomplish that goal. The view was that the murder of more than 3,000 innocent people in the United States justified almost anything in order to punish those who were responsible for those deaths. You and Bybee provided the legal justification for enhanced interrogation techniques that were used to further that goal during the War on Terror. How do we know that you and Bybee didn't believe the advice they were giving in the torture memos? Both lawyers are, by all accounts, brilliant and highly accomplished, so it wasn't a case that they didn't know what they were doing or were simply mistaken. In fact, it's precisely because the authors were such good lawyers that no one believes they could have written the torture memos, which were so riddled with errors in legal reasoning, in good faith. On the contrary, the only reasonable explanation is that they wrote the torture memos to justify the conduct that their client, the Bush administration, wanted to undertake, even though they knew that conduct was unlawful. The 2009 OPR report detailed a host of issues with the legal reasoning reflected in the torture memos. First, the memos left out the sole case on the topic of water torture, United States versus Lee, likely because it identified actions similar to waterboarding as torture. Second, the definition that was used in the torture memos as the legal definition of torture was drawn from a Medicare statute, which defines severe pain as equivalent in intensity to the pain accompanying organ failure, impairment of bodily function, or even death. In using this definition, the authors were trying to provide a higher standard for what level of pain would be allowable during and following enhanced interrogation techniques than what would be allowed under a more simple dictionary definition of torture. The authors doubled down on this approach when they further attempted to justify egregious levels of torture as long as the torture was done out of necessity or self-defense. But unlike the common sense definition of self-defense, that is, in defense of the person who was dealing with the suspected terrorist, the authors reframed self-defense as self-defense of the United States. Third, the torture memos failed to cite the steel seizure cases, Youngstown Sheet and Tube Company versus Sawyer, a seminal case taught to all first-year law students to highlight the powers of the executive during times of war. According to the 2009 OPR report, all of these legal manipulations were used by the authors in the terror memos to create a perverted misunderstanding of the law that was used to justify heinous and illegal torture by the United States. Indeed, the OPR viewed all of these errors in their totality to find that there was a bad faith effort to contort the law to reach a desired result. Similar to my observations at the start of today's presentation, faced with a dearth of case law interpreting the duty to provide candid advice under ABA Model Rule 2.1, the OPR outlined standards for when an opinion clearly violates candor. Those standards were 1. Exaggerating or misstating the significance of the authority that supported the desired result. 2. Ignoring adverse authority or failing to discuss it accurately and fairly. 3. Using convoluted and counterintuitive arguments to support the desired result, while ignoring more straightforward and reasonable arguments contrary to the desired result. 4. Adopting inconsistent reasoning or arguments to favor the desired result. 5. Advancing frivolous or erroneous arguments to support the desired result. Applying these factors, the OPR found that you and Bybee had violated their ethical duty to provide candid legal advice, and recommended that they should be referred to their state bar disciplinary authorities for discipline. This would have been the result were it not for then Associate Deputy Attorney General Margolis, who was tasked with reviewing the 2009 OPR report. Mr. Margolis rejected referring you and Bybee for discipline, finding that despite there being, quote, some significant flaws, end quote, in the memos, the flaws did not warrant a finding of professional misconduct. Mr. Margolis justified the author's mistakes as a product of the times, pointing heavily to post-9/11 anxiety and arguing that the war on terror simply clouded you and Bybee's judgment, and there was no intentional ill will. As a result of Mr. Margolis's decision, the 2009 OPR report was shelved, and neither you nor Bybee was referred for discipline. Clearly, I have a point of view on the torture memos, and whether you and Bybee should have been referred to state bar disciplinary authorities for their conduct, but I recognize that others may hold different views. For the purposes of our presentation today, you don't need to agree with me in order for you to leave today with our key takeaway from this section, which is that lawyers can violate ABA Model Rule 2.1 if they fail to render candid advice. One way that lawyers can fail in this duty is to provide advice to their client that they don't in fact believe is accurate. Lawyers might be tempted to do this in cases where their client very much would like to take a course of action, and the client is looking to the lawyers to justify that course of action and confirm that it would not be illegal. This is the danger area that you must avoid in order to discharge your legal ethics obligations under ABA Model Rule 2.1. As another commentator wisely observed, quote, "There are many situations where the client implicitly wants the lawyer to be less than candid, such as situations where a client wants a legal opinion to absolve them of their desired wrongdoing. But that is not the job of a lawyer, and the rule and its comments do not exempt lawyers from sharing uncomfortable truths about the law. Unlike lawyers in court who may make claims as long as they are non-frivolous, lawyers as advisors should provide advice that is candid and in their best judgment." Such a distinction is important because, while in a courtroom, a lawyer's faulty logic or interpretation of the law can be challenged. Within the private attorney-client relationship, advice often remains unreviewable. In such scenarios, lawyers who violate ABA Model Rule 2.1 by merely telling their client what they want to hear have failed to achieve the basic task of their job, making their client aware of the law. Doing otherwise turns a lawyer from an advisor to a rubber stamp and provides no actual value to a client, end quote. Another commentator likened lawyers who are acting as rubber stamps for their clients to medieval popes who sold indulgencies to noblemen, terming such lawyers as absolvers or indulgent sellers, and reminded us that Dante consigned the indulgence-selling popes to hell. Suffice it to say that you don't want to be a lawyer who occupies this role for your clients. This is true even if it is unlikely that you would be caught acting in this manner, because the attorney-client privilege most likely would shield the advice you give your clients from being discovered and scrutinized for a potential violation of ABA Model Rule 2.1. In that way, the torture memos are unique because they were leaked to the public. Otherwise, the advice that you and Bybee gave to the Bush administration might never have seen the light of day. Once again, this is part of the reason why there are so few disciplinary cases under ABA Model Rule 2.1. It is rare enough that disciplinary committees are privy to a sufficient amount of the lawyer's advice to be thoroughly analyzed. So it is even rarer that the advice is disclosed and then found to be deficiently competent or dishonest. That is exactly what happened with the torture memos, at least with regard to scrutiny in the 2009 OPR report, but only because the memos were leaked, and as noted, Mr. Margolis stepped in to quash the proposed referral to state bar disciplinary authorities before their ethics violations could be investigated or any sanctions imposed on you or Bybee. That case truly is the exception that proves the rule. Before we leave this section, we also need to mention briefly ABA Model Rule 1.2 D, which provides that a lawyer shall not counsel a client to engage or assist a client in conduct that the lawyer knows is criminal or fraudulent, but a lawyer may discuss the legal consequences of any proposed course of conduct with a client and may counsel or assist a client to make a good faith effort to determine the validity, scope, meaning, or application of the law. This is another legal ethics rule that lawyers may not cross, and there are scores of disciplinary cases where lawyers were disbarred for violating this rule. Think about lawyers who help their drug-dealing clients launder their money, or in the worst cases, become active participants in the drug trafficking itself. Tellingly, The 2009 OPR report did not find that you and Bybee violated ABA Model Rule 1.2d, presumably on the theory that it was the Bush administration that decided whether to use enhanced interrogation techniques, and it was not up to the authors to make that decision. That said, having provided the legal justification for this conduct, and if you agree with me that the authors didn't believe the advice they were giving, I think a violation of ABA Model Rule 1.2d could have been sustained against you and Bybee. Whether or not their conduct violated ABA Model Rule 1.2d, very few would claim that the torture memos represented a good faith effort to determine the validity, scope, meaning, or application of the law as it related to the proposed use of enhanced interrogation techniques. ABA Model Rule 1.2b also merits a brief mention. It states that a lawyer's representation of a client, including representation by appointment, does not constitute an endorsement of the client's political, economic, social, or moral views or activities. Another reason that lawyers should give honest advice to our clients is that we are not tied to our client or to his or her actions merely because we are representing the client. If you represent a drug dealer in a criminal case, you are not condoning drug dealing, and as we all know, every defendant deserves a capable defense. Clients need lawyers to give them honest advice, whether that advice is to plead guilty or to go to trial on the charges based on the lawyer's honest evaluation of the case against the defendant, and that is what lawyers must do. We should never be thinking about how our representation of a client or the advice we give that client will make us look to others, and that is what ABA Model Rule 1.2b expressly underscores. So give your client your honest advice and let the chips fall where they may. In doing so, you will be complying with your legal ethics obligations. The only way you can get yourself in trouble is when you give your client the advice that he or she wants to hear when that is not your honest view of the facts and the law that apply to your client's situation. We turn now to our last of the three duties under ABA Model Rule 2.1, which is the part that states that in rendering advice, a lawyer may refer not only to law, but to other considerations such as moral, economic, social, and political factors that may be relevant to the client's situation. Because this duty is styled as a may and not a shall, it is not an ethical obligation, but rather a suggestion from the ABA on how lawyers should behave. So that is an important point of distinction from the other two duties that we've covered today. Obviously, that is also why no lawyers have been disciplined under this part of ABA Model Rule 2.1, because you can't be disciplined for violating guidance that is not mandatory. Interestingly, while New York and most other states adopted this part of ABA Model Rule 2.1, California left it out. I am not sure why California did so, possibly because it is advisory and not mandatory, and I'd be interested to hear from anyone who has some insight on that point. In any case, in terms of fleshing out this obligation, our first stop is the commentary to ABA Model Rule 2.1, and specifically comment numbers 2, 3, and 4 that speak to this part of the rule. Comment number 2 states that advice couched in narrow legal terms may be of little value to a client, especially where practical considerations, such as cost or effects on other people, are predominant. Purely technical legal advice, therefore, can sometimes be inadequate. It is proper for a lawyer to refer to relevant moral and ethical considerations in giving advice. Although a lawyer is not a moral advisor as such, moral and ethical considerations impinge upon most legal questions and may decisively influence how the law will be applied. I think the best example of this guidance comes from the litigation context. If you are a litigator, you likely will be advising your client on the merits of the claims that are at issue in the case. Let's say you are on the defense side, and so you will be advising your client as to whether the claims being brought by the plaintiff are likely to succeed or fail. That is the baseline of what every lawyer should do. What ABA Model Rule 2.1 and comment number 2 are suggesting is that giving your assessment of the merits of the case against your client should be the beginning of the story, but it should not be the end of the story. Based on the statistic that nearly 95% of all cases settle prior to the end of a trial on the merits, in nearly all cases, it is better for the client to avoid litigating a case through to trial, even if the client will win because of the cost and client distraction a trial would visit upon the client. ABA Model Rule 2.1 suggests that you should be including those considerations when you are advising your client in connection with a litigation matter. Corporate, tax, environmental, and other representations, of course, are different, but the principle is the same. If your client is set on a path that is legally valid, but due to legal fees or other costs, it is not the best course of action in your opinion, you should advise the client of that view and not limit yourself to simply opining on the validity or invalidity of the client's legal position. No client wants to score a Pyrrhic victory in a litigation or other representation, and you can play a key role in helping clients avoid that outcome based on your knowledge and experience as a legal professional. I think the best in-house lawyers do this really well. To give you one example, I can't tell you how many times I have been asked by a business client to answer a legal question, and I have responded with something like, "There is an answer to your legal question, but I think first we need to consider whether we are asking the right question." The point is that sometimes the right answer to a business problem doesn't turn on the answer to a specific legal question, but rather there is another, better way to address the issue. You see this very often with disputes between companies who regularly do business with each other. Unless the other company is going out of business or is insolvent or something like that, nearly every dispute that arises can and should be resolved by a negotiation between the parties. Even if your company is 100% right on the issue as a legal matter, for example, the contract language is perfectly clear and it vindicates your position, you're never going to sue the other company, except in the rare cases I mentioned, because that route is too costly and too long of a road to yield the results you want in this fiscal quarter or year, and for these reasons, a negotiated resolution nearly always makes sense. To my mind, this is what ABA Model Rule 2.1 is talking about when it suggests to lawyers that advice couched in narrow legal terms may be of little value to a client, especially where practical considerations, such as cost or effects on other people, are predominant. Purely technical legal advice, therefore, can sometimes be inadequate. Most lawyers do this naturally, and it's nice that ABA Model Rule 2.1 gives us license to include practical considerations in our advice to our clients. The last part of the guidance in comment number 2, relating to moral and ethical considerations, is a meaty topic, so I am going to skip over it now, but we'll be sure to discuss it in detail before we close. Moving on to comment number 3, that provision states that a client may expressly or impliedly ask the lawyer for purely technical advice. When such a request is made by a client experienced in legal matters, the lawyer may accept it at face value. When such a request is made by a client inexperienced in legal matters, however, the lawyer's responsibility as advisor may include indicating that more may be involved than strictly legal considerations. To paraphrase the comment, if you have a layperson as a client, you need to answer around the question. In other words, answer the client's question, but also make sure that you consider and provide advice on the other issues that might be relevant to the client's situation based on the question. This one is pretty easy to understand with a simple example. If a layperson consults with you about some damage that he or she has discovered in the attic of her home and asks you what the statute of limitations is to sue the builder for negligence, your advice shouldn't be limited to reporting back that the statute of limitations for negligence claims in your state is 2 years. You need to think about what else might be relevant to the client's situation, with the obvious example being the discovery rule, which potentially would extend the statute of limitations to allow claims to be filed within 1 year from the date of discovery of the damage. If you were to answer narrowly, the client might assume that because she has owned her home for 5 years, her claims of negligence against the builder would be time-barred. On the flip side, if your client were the builder who you know to be experienced in such matters, you could answer the question posed narrowly without risking that your experienced client will be misinformed about potentially relevant considerations like the discovery rule. Finally, comment number 4 provides that matters that go beyond strictly legal questions may also be in the domain of another profession. Family matters can involve problems within the professional competence of psychiatry, clinical psychology, or social work. Business matters can involve problems within the competence of the accounting profession or of financial specialists. Where consultation with a professional in another field is itself something a competent lawyer would recommend, the lawyer should make such a recommendation. At the same time, a lawyer's advice at its best often consists of recommending a course of action in the face of conflicting recommendations of experts. Once again, I think this guidance is sensible and pretty easy to follow. There are times when lawyers should suggest that clients hire experts. This can be everything from your expert witnesses in litigation matters, to environmental experts in real estate, to valuation experts in M&A matters. And lawyers also can play a role in helping the client manage those experts and interpret the expert advice that they will be providing to the client. Part of this relates to managing costs. Lawyers should do their part to ensure that the experts they recommend are providing great value for the client and are not turning over stones that don't need to be turned over, but part of it relates to helping the client understand how the expert's advice will be received in the matter that the lawyer is handling for the client. In litigation, lawyers usually pick the experts, particularly the ones who will be testifying for the client, because they want to control how that expert testimony will come in for purposes of summary judgment or at trial. In transactional matters, lawyers also can play a key role in making sure that the right level of expert, in terms of cost, but also expertise, is retained by the client that is a good fit for the client's situation. As experienced professionals, lawyers are generally pretty well suited to do these sorts of things as it relates to experts, and ABA Model Rule 2.1 is just saying that we should embrace this role and not shy away from it. Our final topic today is to make sense of the guidance in comment number 2 that states that it is proper for a lawyer to refer to relevant moral and ethical considerations in giving advice. Although a lawyer is not a moral advisor as such, moral and ethical considerations impinge upon most legal questions and may decisively influence how the law will be applied. At first blush, this language seems to suggest that lawyers should be giving moral and ethical advice to clients, which I think would strike most lawyers as odd and most clients as unwelcome. In addition, while I can see the ABA's point when they say that some legal questions turn on the morality or ethics of the situation, think of a case where one of the parties to a litigation comes to the court with unclean hands or otherwise has displayed morally or ethically suspect behavior. Courts will go out of their way to resolve legal questions against that party where possible in terms of doing equity. So I suppose that the general advice that it is okay for lawyers to try to talk their clients out of doing things that the lawyer thinks are amoral or unethical is perfectly fine as far as it goes. Most clients aren't going to defer to their lawyer on what is moral or ethical, particularly if we are talking about a sophisticated or institutional client. But I am sure that many unsophisticated clients would be influenced by what their lawyer might say to them with respect to morality and ethics. And the way I like to think about this part of the guidance in ABA Model Rule 2.1, and one of the reasons that I think ABA Model Rule 2.1 is really useful for lawyers, is that it gives you license to try to talk your client out of asking you to take a position that you think is amoral, unethical, or just a really bad idea for reputational or other reasons. The example I like to use here are when lawyers are negotiating on behalf of our clients. This can be negotiating a business deal or negotiating to settle a litigation matter. In either case, the law and the legal ethics rules limit what you as a lawyer can do in the context of representing your client in that negotiation. In a nutshell, you can't lie to the other side about material facts or law, and you can't lie about your client's bottom line or your settlement authority. There are other rules too, and if you are interested in learning more about this, we have an entire series of programs entitled Negotiation Ethics for Lawyers that likely are available on the same service where you are viewing this program. What neither the law nor the legal ethics rules requires lawyers to do, however, is to negotiate in good faith. There is some aspirational guidance out there that suggests that lawyers should negotiate in good faith, but absent a contractual or other pre-existing duty to negotiate, which if it exists would require that duty to be performed in good faith under the law of contracts. Lawyers have no duty to negotiate in good faith under the law as it exists in the United States. Now, I think lawyers should negotiate in good faith because doing so produces better outcomes, the deals you reach are more likely to be performed better and less likely to lead to disputes down the road if the other side feels that the agreement that was reached was fair, as opposed to a case where the other side feels that it was forced to make a deal with you because you negotiated in bad faith. The other reason I favor good faith negotiation is because the opposite, acting in bad faith, using negotiation dirty tricks and taking sharp edges, is going to harm your professional reputation. And once you get a reputation for being a shady negotiator, your reputation will follow you. That will make it harder for you to make the next deal because the other side will take a harder line against you because they know you are a dodgy player, and that will end up making you less effective for your clients than you would be if you chose to negotiate in good faith. All of this is prelude to my example, which is what if your client wants you to engage in bad faith negotiation? That isn't barred by the law or the legal ethics rules, and as long as you are not lying to the other side about material facts or law, what the client is asking you to do is permissible. But if you're like me, you don't think that approach is the best one for reputational consequences, and also because you don't think reaching an agreement through bad faith negotiating will produce a deal that is durable, that is, a deal that will be performed well by the other side and not give rise to disputes later on. This is where ABA Model Rule 2.1 comes in. It gives lawyers the ability to push back on the client by appealing not only to law, but to other considerations such as moral, economic, social, and political factors that may be relevant to the client's situation. In my example, I would have the opportunity, instead of feeling obligated to engage in that conduct, to have a discussion with the client and explain why something might be technically within the law and the ethical rules, but implicate notions of fairness and justness and morality. That's certainly fair game, and it's the kind of thing that hopefully lawyers are talking to their clients about, as opposed to setting an example for really the most aggressive or egregious conduct in negotiations. I think the scenario where your client presses you to take a very extreme position or use other bad faith negotiation tactics comes up a lot in the real world. Often you're in a spot where you're negotiating not only with the other side, but with your client about why taking a dodgy position or sharp edge, something that's arguably crossing the line, and how that isn't really in the client's interest. It can be extremely difficult if your client is coming to you and saying, "You've got to go out there and get me the $4 million I am asking for to settle this case. I don't care what you have to do it. You're my lawyer. You need to be zealous and advocate for me." We may have more or less control of our client depending on the situation, but in all cases, we should be grateful that we have ABA Model Rule 2.1 to give us cover under the ethics rules to attempt to persuade a client not to take an extreme position or to engage in other bad faith tactics. You should use it when needed. It should go without saying that "I was only following my client's instructions" is not a defense to a legal ethics violation in cases where your conduct is found later to have crossed the line and you have violated a legal ethics rule. Even where you can avoid acting unethically, the fact that your client asked you to behave in this way is not salve for a badly injured professional reputation. One concrete example of a negotiation tactic that a client might ask you to take is to threaten the other side in a negotiation. Making threats is generally understood to reflect bad faith or to represent a dirty trick in negotiating, but it's not prohibited by the law or the legal ethics rules. How might you use ABA Model Rule 2.1 to talk your client out of asking you to threaten the other side in a negotiation? First of all, I should point out that you don't have to try to talk your client out of it. This part of ABA Model Rule 2.1 is a may and not a shall. So you can't be disciplined in this example for following your client's instructions as long as what you do for the client doesn't violate the law or the legal ethics rules. But if you want to talk your client out of asking you to threaten the other side, ABA Model Rule 2.1 gives you a basis to do that, and I think it's a good idea for the reasons I mentioned before. In that case, you would go to your client and explain that while we could make this threat, most people don't react well to being threatened, and so making such a threat likely won't result in the other side agreeing to our demands. On the contrary, it probably will cause them to harden their position, which means that in the context of a dispute, a lawsuit will be filed and likely pursued for a while, causing both sides to incur hassle and expense, before the parties decide to try again to negotiate a settlement. That is probably not in your client's interests, and so I might make that point to the client in an effort to talk the client out of taking such a hardline approach. But at the end of the day, if the client wants to play hardball after I inform the client of the risks that the tactic won't achieve the result the client intends, I wouldn't have an issue executing on that strategy as long as I don't believe it violates the law or the legal ethics rules. But I would avail myself of the license given to me by ABA Model Rule 2.1 to do my best to talk my client out of a course of action that I think is a mistake. That's what lawyers are supposed to do if we have as our singular focus, as we must, our client's welfare and interests. That brings us now to the end of our program. I hope you enjoyed learning about ABA Model Rule 2.1 and that you keep it top of mind in cases where you might find it useful in managing your client relationships. Thanks for joining me.